At shortly after 6:30 in the evening, on Sunday the 22nd of September of last year, in broad daylight, the life of 15-year-old Daejaun Campell was snuffed out when he was stabbed to death on a street in Woolwich. His fatal wounds were inflicted by you, Imri Doue, with a large machete with which you had quite deliberately armed yourself, as you admitted to the jury that you had done hundreds of times before. You were convicted of Daejaun's murder by the jury, who rejected your false assertion that you were acting in lawful self-defence. You, Marko Balaz, were convicted of manslaughter on the basis that you encouraged and or assisted Imri Doue to stab Daejaun, but without the requisite intent for murder. There is no question but that was the jury's findings, because that was how I directed them in the route to verdict. You are both here today to be sentenced for your involvement in Daejaun's killing. You, Imri Doue, are also here for possession of the machete, which was the murder weapon. You, Marko Balaz, are also to be sentenced for drugs offences. Daejaun Campell was, in his mother's words, quotes, an incredible human being, son, brother, cousin, and friend. He was loyal to a fault, caring, compassionate, helpful, understanding, and a brilliant communicator. She describes how he excelled at sport. The grief which his violent death has caused is immeasurable. It is felt most keenly by his mother, but also by his grandmother, his siblings, other family members, and friends. The impact of Daejaun's death reaches far and wide, and his death has left behind a huge void. His mother, who has behaved throughout this case with dignity, asks herself the same question that we ask on a daily basis in this court: when will this knife crime epidemic end? As she rightly says, enough young lives have been lost already, and nothing that I can do today can bring Daejaun back, or, it seems, stop others from behaving as you two did. Daejaun was himself a victim of local gang culture and had clearly been groomed and sucked into a life of Class A drug dealing, as so many young, disaffected teenagers in this city are. He had entered a world where the carrying of lethal knives was the norm. In his naivety, he no doubt believed that carrying a knife would protect him. His mother truly believes that he was on the very brink of giving up his criminal lifestyle and that he was due to go back to school the day after he was murdered. Thanks to the actions of the two of you, he will never do so. He will never be able to capitalise on all the positive attributes which he clearly had. Before turning to the facts, I make it clear that where I make findings adverse to either of you, I do so to the criminal standard. On the 22nd of September of last year, the two of you met up together with Jacob Losiewicz, who was acquitted of any offence. Jacob Losiewicz drove you to an address to which he had access in Eglinton Road in Woolwich. You had been to the address before. From that address could be seen a well-trodden path where you knew you might find local boys such as Daejaun Campell, who for some reason, no doubt related to some sort of pathetic gang rivalry, was a target of your aggression and needed to be G-checked. Perhaps you didn't bargain for the fact that Daejaun would be armed with a knife himself, or that he would try to stand his ground. As you saw Daejaun head up the path, you ambushed him. You had your heads and faces covered. You, Imri Doue, had a large zombie-style machete in a sheath. When you reached the top of the path, you confronted Daejaun, who quickly dropped his knife. His knife broke, and from that moment he was defenceless. I completely reject the assertion that he had a second knife. As you told the jury, Imri Doue, adrenaline kicked in, and the two of you chased Daejaun as he tried to run away. You, Imri Doue, stabbed him a total of 8 times. One wound was to his head, and other injuries to his arm and hands were caused when he tried to protect his head from further injury. You also stabbed his thigh and ankle. The fatal injury was delivered with at least moderate force as Daejaun was running away. Your machete cut the femoral vein in his leg and penetrated to such a depth that the knife hit the pelvic bone. You may not have intended to kill Daejaun, but there was an extremely high likelihood of death, bearing in mind the location of that fatal wound and the nature of the weapon which you used. You, Marko Balaz, were right there. You provided backup, knowing that Imri Doue had drawn his machete, and as the jury found, you encouraged him to stab Daejaun, intending that Daejaun suffer significant, albeit not really serious, harm from stab wounds. As Daejaun lay bleeding to death and calling for his mother, you two ran off, taking the machete with you. You went back to Eglinton Road, where you both laid low for some hours. You, Marko Balaz, had to be home by 9 p.m. to comply with the curfew, which was one of the bail conditions for the drugs offences. You ordered a taxi in a false name, and having been collected some distance away from Eglinton Road, you headed home. Following your arrest, you told a pack of lies in your police interview. You, Imri Doue, did not go home. You told the jury that you enlisted the help of a caring friend who was clearly a fellow criminal, who helped you to get rid of your phone, blood-stained clothing, and the murder weapon. I have no doubt that there was incriminating material on your phone which would have showed the motive for and the plan to attack. You obtained a new phone, changed your clothes, and went home much later that night. Meanwhile, Daejaun was pronounced dead at the scene. He had bled out from a major femoral vessel injury. The messages between you, Imri Doue, and your girlfriend show that you recognised what you had done and that you were facing a long sentence. You described it as karma. When in custody following your arrest, you were clearly distressed and owned up to being responsible, but you did not have the courage to plead guilty. During and since the trial, you have begun to realise the enormity of what you did. You, Marko Balaz, recorded images of the scene and of Daejaun. Whilst in custody, you boasted to your cousin and girlfriend that you had been responsible for the killing and that it was you that had stabbed Daejaun. Listening to those calls increased the distress for Daejaun's mother, who had to hear you showing off about her son's death, your involvement in it, and your complete dismissal that a young boy had died. In the light of the jury's verdict, however, I cannot be sure that you had a knife, and I will not sentence you on that basis, despite the contents of those prison calls. On the other hand, you did know that Imri Doue was armed with a machete. The two of you are no strangers to the carrying of knives. You, Imri Doue, are now 18. You were 17 at the date of the murder. You told the jury that you've regularly carried knives, including machetes, since you were 13. You have a caution from October 2020 for possession of a knife, when you were only 13. You have a conviction for possession of another knife 3 days later, for which a referral order was imposed. You have yet another conviction for possession of a knife less than 8 months later, in June 2021. That weapon was a large kukri knife. Less than a year before the murder, you were convicted of possession of a machete and a fray. For those offences, you received a 12-month youth rehabilitation order with intensive supervision. The murder was committed during the currency of that order, and it is quite clear to me that all attempts at helping you to leave that way of life behind you had failed despite intensive intervention. You, Marko Balaz, are now 19. You were 18 at the date of the killing. You have 2 separate convictions for possession of knives in 2023. You too failed to respond to intensive supervision. At the time of the killing, you were on bail with an electronically monitored curfew for possession with intent to supply cocaine, heroin, and cannabis, and for possession of the criminal proceeds of your drug dealing. Those offences to which you very recently pleaded guilty occurred on the 8th of July of last year. At 7:15 that evening, you were stopped by police and found to have over £500 in cash, £60 worth of cannabis, and 17 wraps of crack cocaine. When you were searched more thoroughly, 13 more packages of cocaine and 5 of heroin were found hidden in your underwear. Examination of your phone revealed that you were advertising drugs for sale back to January of 2023. Imri Doue, you are now aged 18. At the date of the offence, you had recently turned 17. I begin with the murder, which carries a mandatory life sentence. As you were 17 at the date of the offence, I must order you to be detained during His Majesty's pleasure. I then have to determine the minimum term that you must serve before you can be considered for release by the parole board. You took a knife to the scene and had it available to use as a weapon and used it to commit the murder. Therefore, paragraph 5A of Schedule 21 of the 2020 Sentencing Act applies. That gives a starting point for the minimum term of 23 years based on your age at the time of the offence. I bear in mind that had you been 16, the starting point for the minimum term would have been 17 years. I then have to consider aggravating and mitigating factors. The relevant aggravating factors are 1, your numerous previous offences of knife possession and the fact that, as you told the jury, you have regularly carried a knife since the age of 13. 2, the obvious planning to confront Daejaun or someone else from the area, including the use of disguises, although to some extent the planning is reflected in the starting point, and I do not add significantly to the minimum term to reflect planning further. Thirdly, your actions after the murder of disposing of your clothing, phone and the murder weapon. And fourthly, the fact that you committed the offence during the currency of a youth rehabilitation order which had been imposed for knife possession and violence. Those matters would justify a significant increase in the minimum term. Turning to mitigation, I have read the intermediary report, the psychological report and the pre-sentence report. It is extremely depressing to note that despite a loving home, to which your mother refers in her statement, which I've also read, with a caring and responsible parent where you grew up as a well-behaved child with enormous potential. In 2020, when your mother was out of the country, you were clearly groomed by older boys and, like Daejaun, sucked into a world of gangs and knife crime. In August 2024, you were declared to have been a victim of child criminal exploitation. By September, your life consisted of smoking cannabis with your friends and wandering the streets of Woolwich with a lethal weapon. You have made good progress while on remand, and sadly now I think you are finally beginning to understand the dangers of carrying knives and the fact that young teenagers are being killed and others locked up for large parts of their lives. I accept that you now regret your actions and are to some extent remorseful. Your youth is already reflected in the reduced minimum term. I am prepared to find that you did not intend to kill Daejaun, but as I've already said, there was a very high risk of death, so that justifies little reduction in the minimum term. Having considered everything in the reports, including your immaturity and naivety, as well as your limited intelligence and understanding of what you were doing, and the remorse we are finally demonstrating, I have decided that the mitigating factors outweigh the aggravating factors, due not least to your youth. The minimum term I finally decided upon is one of 21 years. There will be a short concurrent sentence for the knife offence, which will be reduced by 33% to reflect your guilty plea. I will spell out the precise sentence at the end of these sentencing remarks. Marko Balaz, you are now 19. I begin with the manslaughter. I sentence you on the basis that you encouraged Imri Doue to stab Daejaun as part of a planned and targeted attack, but of course I recognise that you didn't intend that Daejaun should be killed or hurt very seriously, though you clearly intended significant injury. Having considered the sentencing guidelines, I have concluded that this offence falls within culpability B, due to the fact that the death was caused in the course of an unlawful act, which must have involved an intention to cause harm just short of grievous bodily harm, and which carried a high risk of death or really serious harm, which ought to have been obvious to you. That gives a starting point of 12 years and a range of 8 to 16 years. However, your responsibility is reduced to some extent due to your significant learning disability, which I will treat as an important mitigating factor. The aggravating factors are, firstly, your previous convictions for knife possession, which are, in my view, relevant and sufficiently recent. Secondly, the fact that the offence was committed when you were on bail for serious drug offences. And thirdly, the fact that you were the subject of a youth rehabilitation order at the date of the offence. I have read the pre-sentence report, which accurately sets out your background and your future risk. The mitigation is your youth, your lack of maturity, and most importantly, your very significant learning disability, which means that you have an extremely low level of intellectual functioning and a very real mental impairment, which I am sure makes you more susceptible to negative influences and impulsive acts. Subject to the question of totality, to which I will return, I have concluded that the least sentence which is appropriate for the manslaughter on its own would have been one of 10 years. I then have to consider whether you qualify as a dangerous offender. Whilst I have concluded that you do so qualify, in the light of the sentence which I'm going to pass upon you, I do not consider that it would be appropriate further to extend the licence period, and therefore I propose to pass a determinate sentence upon you. I turn then to the drugs matters. Your offending falls within significant role at Category 3 of the relevant guideline, which for the Class A offences gives a starting point of 4.5 years and a range of 3.5 to 7 years. Concurrent short sentences are appropriate for the cannabis and criminal property offences. The aggravating factor is your failure to comply with earlier orders. The mitigation is the same as for the manslaughter offence. The sentence prior to consideration of your late pleas would be one of 42 months. That would be reduced to 34 months to reflect just under 20% credit before I deal with totality. Before I deal with the final sentences, I deal with ancillary matters. Any outstanding orders for either of you will be revoked, and I take no action on the breach of the conditional discharge in your case, Mr. Balas. The phone and money seized from you will be forfeited and the drugs destroyed, and you will both pay the statutory surcharge. Would you both please stand up? Imri Doue, for the planned murder of 15-year-old Daejaun, whom you targeted and stabbed to death with a lethal machete when he was defenceless and posed no threat to you, the sentence is detention at His Majesty's pleasure for a minimum term of 21 years to punish you for what you did. That is the term you will serve before being considered for parole, and you will not be released unless it is determined that you no longer pose a significant risk of harm to the public. For the possession of the knife, there will be a concurrent term of 8 months custody. You have spent 370 days on remand, which reduces the minimum term to one of 19 years and 360 days, and that is the term which I impose. Marko Balaz, in order to reflect totality, I do intend to reduce the sentence for the manslaughter in respect of which you participated in a fatal attack upon Daejaun with Imri Doue, who you knew was armed with a machete and who you encouraged to stab him. The sentence for that offence is 9 years detention. I reduce the sentence on counts 1 and 2 on the drugs indictment from 34 months to 2 years on each offence to run concurrently to each other, but consecutively to the 9 years, giving a total of 11 years detention. That will be reduced to 10 years and 328 days to reflect the qualifying curfew. For the cannabis offence and the criminal property offence, there will be concurrent 3-month sentences on each. Should my calculation of the days on remand or the qualifying curfew be incorrect, the parties must notify the court by 4:30 p.m. today, and I will have the case called back on and adjust the term. They may go down.